First case on the docket this morning. It is from Cowley County. It's number 127767, entitled Blackjack Hills versus the estate of Billie Webster et al. Counsel could come forward. And who do we have here for the appellant?
May it please the court, Your Honor, I'm Joe Knopp, representing Blackjack Hills. Joni Webster is the Chief Executive Officer, President of Blackjack Hills.
All right. And who do we have here for the appellee?
May it please the court, I'm Christopher Rogers. I represent the estate of Billie Joe Webster, his son, and the administrator of the estate, who is Luke Webster, who is present with me. And I also represent the decedent's daughter, Bridie Punzel, who is a pharmacist in Hawaii and couldn't make it.
Okay. All right, thank you. Mr. Knopp, whenever you're ready to proceed. And do you wish to reserve any of your time for
I'd like to reserve 5 minutes, please.
That is granted.
Let me state that this case is a significant case because it will establish the limitations that a district court can have to invoke equity and the theory of constructive trust to void contract terms, to supersede statutes, to potentially affect statutes of limitation, potentially affect the laws of dissent, potentially affect the laws of joint tenancy, power payable on death and transfer on death transactions. Because under this theory that is espoused by the court in this case, the district court, if the court finds that there's equitable considerations, that find then that there's unjust enrichment, that if the court makes those two findings, then the court can impose a constructive trust and change the outcome of the case. This case started as a declaratory judgment case to define the contract, the insurance policy. It's turned into a claim for unjust enrichment, for a constructive trust to try to change the outcome or the terms of that insurance policy. Under the insurance policy, Blackjack Hills is the named beneficiary. We believe that this is important for those reasons. As you know, the district court in the divorce stated that the plaintiff, or stated that Billie Webster should have set aside to him certain property, and that the ownership of the property, ownership of the insurance policy would be transferred to him from Blackjack Hills. The court did not order that the beneficiary designation be changed. And under Kansas law 23-2802, the legislature has specifically said that you must designate, or you must change the beneficiary, that the divorce itself doesn't change the beneficiary. Now, the legislature could have gone the other way. It could have said a divorce automatically terminates the beneficiary designation, and a spouse who's formally named as the beneficiary is no longer a beneficiary, or the beneficiary who's named on the policy is no longer that because it's been set aside to the new owner, i.e. the husband.
And that statute covers policy that's owned by the parties to the marriage, correct?
It is. Now,
and technically we don't have that here, right?
Technically we don't, and yet the ownership is so tightly owned by one party, by Joni Webster. She is the chief executive officer. She's the president, sole stockholder. She is the person who is involved with that. I would suggest to you that in these constructive cases that have been cited, the Nelson case, the Dapper case, the court expanded constructive trust by saying that no longer do we have to have actual or constructive fraud for there to be a constructive trust imposed. But in each one of those cases, there was a specific race, a specific property that was being transferred, specific right that was designated. For example, in those cases, there were prenuptial or a postnuptial property settlement agreement that said you shall receive X dollars from this estate, or you shall receive, in the Hilson case, I'm pronouncing it wrong. It's an old case, what they said, where the decedent specifically told his cousin that he was going to get the proceeds of an insurance policy. There was a race there that was specifically designated. In this case, the race that is specifically designated is the ownership of the policy, not the beneficiary. The owner then has the right to designate it. Now, counsel has argued that the transfer of ownership document that was filed with the insurance company, and when it was filed, the Billie Webster, Joni Webster, and the insurance agent all thought that it was a valid transfer, and they sent it in. But in that transfer, it did not designate a change of beneficiary. And by implication, there was to be no change of beneficiary.
It's pretty clear that the intent of the divorce or decree would have been that the policy's going to Billie, and he could have changed the beneficiary had he had time to do so, but it just didn't work out that way.
Well,
Now, I guess my question to you is, their argument is, and what the district court agreed was, this just didn't seem fair. Now, your argument basically is that it doesn't matter whether it was fair. Is that right?
my argument is that we can't interpret what he intended. We don't know who he intended to be the beneficiary, number one. He didn't leave a will. So we don't know who he intended to have be the beneficiary of his estate. We assume that he meant let the law decide.
Well, the Cincinnati life insurance policy, this case, it's fairly similar to this, but in that case, a husband got a policy through a divorce, and then just 2 years went by, and he never bothered to change the beneficiary. And so when he died, the court ruled you're stuck with what it who it says the beneficiary is. But those aren't our facts here.
Death is an unfortunate.
Billie didn't. It wasn't that he waited for 2 years. He never even. He couldn't have possibly changed the beneficiary because it was never transferred over before he died.
No, not correct. I don't believe that's a correct interpretation of the contract or the law. We all agree that as of August 28th, Billie was an equitable owner of that policy. And Billie could have woken up every morning saying, wait a minute, that policy is still in effect, I don't need to change the beneficiary. And he could have gone down to the New York Life agent and said, I want to change this, I want to do this, I'm the equitable owner.
The decree hadn't even been filed. The ink hadn't even dried
But
yet.
that's his problem. That's his attorney's responsibility. His attorney was supposed to draft it, and you're right. They thought they had 60 days. They thought they had plenty of time because they didn't know when he was going to die. But the problem is that he had it, they gave it to him on October 28th, 13 days before he passed away. So he had it for 13 days.
What was wrong with the form that they sent in to change ownership that the insurance company wouldn't accept?
Well, it's my position that that's a disputed fact. We say that the insurance company concluded that because there was no beneficiary change, ownership became irrelevant. Their obligation was to pay the beneficiary, and until it's changed, it's not. They argued before the Court of Appeals, before the district court, that Joni Webster, when she signed it, didn't sign it as president of the company. And therefore, that was an effective transfer of ownership. And I argue that a court of equity could, in that situation, revise the contract and say, look, it's the same as her. It's not, it's effective, let's call it a change of ownership. But in that transfer, there's a whole series of boxes. Who do you want to be the beneficiary? To change it, mark it here. He didn't do that. He had the chance to change the beneficiary. Had he gone in front of Judge Elder in the trial court and said, Judge, I want you to designate the beneficiary to be my children. I want you to designate the beneficiary to be whomever, I want it to be so-and-so. And the judge put it in the journal entry, the statute wouldn't apply. We wouldn't be here. Had he said in any one of those boxes, I want so-and-so to be the beneficiary, we would be here saying, is that contract, should that contract be enforced because it is in all terms and conditions enforceable? It seems unequitable and unfair for a person to sign a contract and believe it's valid and then later attack that same contract by asserting that there's a technical designation that's not included. This court could have said, we're going to have the facts decide whether or not this is a valid transfer of ownership and conclude that it was, but at least there ought to be some findings of fact on this. I would suggest to you it's a disputed fact. My affidavit said we didn't even decide ownership because there was no change of beneficiary. But he had the chance.
Is that a legal dispute or a true factual dispute?
Well,
the facts are the facts. And
the facts are that she didn't sign it. The question is whether it's a matter of equity, the court would interpret that contract as being valid and enforce it, notwithstanding that minor technical irregularity. And that would be the option I would suggest that the court had available. But he,
Let me ask you.
Yeah.
The documents that I've read reflect that the only person who can change the beneficiary of the policy is the owner. And so at the time of Mr. Webster's death, the owner of the policy was Blackjack. And so he never was given a chance to change ownership.
No, he was. And the change of ownership was effective upon it being delivered to Mr. Webster and turned into him. The insurance company says it's effective upon our receipt of that, not upon, and so because the death was so quick after they signed that transfer of ownership, the company said, we don't need to get into the middle of this fight. There was no change. If whether or not his decision to not change the beneficiary is important in this case and determined by whether or not that policy the ownership was changed at that time, then we ought to go back to the trial court and say, as a matter of equity, does that transfer of ownership govern and is it important? But the outcome is if it...
Counsel, you've used 10 minutes.
Okay, thank you.
You can continue. I just want you to know
No,
you're going...
thank you. I appreciate you giving me time. But the point is that even if we determine that the ownership changed by not designating the beneficiary change, he waived any right to make that change. And he had that opportunity. He could have called the service center. He could have sent in a beneficiary form. In fact, Ralph Wild, the insurance agent, said, I sent him the forms to change the beneficiary, and he did not send them back. So to argue that but for the ownership transfer, he would have changed the beneficiary is not supported by any of the facts.
May it please the court, I think the arguments or the questions that have been asked pretty much summarize the questions that the estate and the heirs had. The facts this case is neither complex nor confusing. The facts are simple. They've been highlighted in my brief. They've been highlighted by the court. The salient ones are the corporation was owned by the parties during their marriage. At the time of the divorce, the Judge Elder, gave the corporation to Joni Webster and ordered, the corporation owned a whole life policy on the decedent. Neither party owned that. The judge then, without the authority to say to the parties, you got to do this, told Joni Webster to transfer that policy. It was never transferred. As I get the appellant's case, they're saying they blame Judge Elder for not naming the beneficiary. They blame the decedent for not checking a box on the form. They blame New York Life for somehow not effecting the transfer, when in fact the transfer wasn't made because it was not timely done under the court direction. It wasn't transferred to him, and the decedent did the best he could. He signed, dated, and returned. The form was wrong. And at that point, the decedent never had either ownership of the policy, nor did he ever have control through the corporation to change it. And so what we are looking at is, under the circumstances, the district court found that there was a duty which was breached by Joni Webster to transfer the policy. As a consequence of that breach, he found that the constructive trust applied. And as a result of the constructive trust applying to the proceeds, they go to the estate. That really isn't very difficult. The law is pretty straightforward. The cases that have been presented in the brief all say that when there is a breach of an obligation, the equity follows that where the breach occurs and makes right what should have been done according to what was breached by the obligation. In this case, and there's all the cases that were cited, all support the same position.
Well, did the judge find unclean hands in this case?
I'm sorry?
Did the judge apply the unclean or clean hands doctrine in this case?
Yes.
What's the basis for that? Doesn't that require a finding that Johnny acted illegally, unconscionably, fraudulently?
Well, the basis for the unclean hands was that in this particular case, Joni Webster, in her deposition, admitted that she was never supposed to get any of the proceeds from the policy, that she was supposed to transfer the policy within 60 days, and she didn't do it. How can she come into court and say, I did everything right, when she didn't do everything right? And the court's decision on those grounds, but I might also add, it really doesn't matter, because the doctrine of unjust enrichment under all these cases, which is what this creates, applies in this particular case.
You think that's your stronger argument?
Well, there's one more argument. The other argument is this. The policy was an asset of the estate. It was Billie Joe Webster's asset. It was assigned, or was awarded to him at the trial. When he died, that asset became part of his estate. The estate was opened in January. Notice was given, publication notice was given, individual notice was given not only to Joni Webster's attorney, but to Joni Webster herself as owner of the corporation. No claim was ever filed in the probate court. 592239 provides that all claims must be presented, whether contingent or not, and if there is a claim being made to the benefits, that should have been made in the probate court timely. It was not. The Nelson case, which is cited for a couple of reasons, points out specifically that in this particular case, in this type of a case, that is an asset of the corporation or of the estate, and there should have been a claim filed in the probate court. There was not.
Could you refresh my memory? Was this part of the district court's ruling? Did the court rely on this, the argument you're making now?
The argument I'm making, we made at summary judgment as well.
Was that part of the court's ruling?
No, the court decided the case on the equitable basis. Our position is that if the judge made the right decision for any reason, and we're giving the court 2 reasons why we believe the decision was correct. And if you have no questions, I'm done.
Apparently not, thank you.
Thank you.
Let me briefly address the question of who was entitled to the benefits. Was submitted as an interpleader by the insurance company. They were initially prepared to pay the benefits to Blackjack. We contend that they were our benefits until the interpleader, until this case. So it's not a situation where they were property of the estate. They were property in the interpleader and hadn't been decided. If you look at the estate proceedings themselves, there's been no inventory filed, no claim in the inventory or in the estate that it's owned. So the result of this declaratory judgment action is should be controlling of the case.
So are you saying that the non-claim statute doesn't apply?
Yes, because just like a payable on death or transfer on death or a joint tenancy, those pass immediately upon death. If the beneficiary passes, the beneficiary collects it immediately upon death. It's not an asset of the estate, and therefore there's no asset to be distributed. In the Nelson case and other cases,
The non-claim statute applies to contingent assets, doesn't it?
well, it applies to contingent assets that are ultimately determined to be owned by the estate. In this case, we've got to interpret who the beneficiary is. Is it the estate? Is it the children? I mean, that's the other problem. We've got an implied, the beneficiary was stated, and once again, the argument is that my client delayed the transfer. The plaintiff's, or Mr. Mitchell's attorney failed to file the journal entry until 54 days up there. So she got everything together. He had plenty of time and did have the opportunity to designate who that beneficiary would be.
But she had the same 54 days to sign the form with the insurance company.
Right.
Changing ownership, even before the journal entry was signed.
Right, correct.
And she didn't do that.
Correct. But I'm not sure that there's any, nobody knew he was going to die.
No, none of
And
us do.
that's the unfortunate thing about an uncertain statute of limitations. When it's a statute of limitations, it happens. In this case, it's an uncertain statute of limitations. But the bottom line is he had 4 days, at least 4 days, maybe 13 days before he died to take care of the beneficiary designation, and he didn't. And that contractual obligation then now becomes the binding, controlling force here, and to try to go in and change that contractually, that contractual obligation is difficult. It requires doing something that hadn't been done before in these cases. In all these cases, there was a race. there was an object that the parties, when they were alive, made an obligation to transfer, whether it was a proceeds from an insurance policy or whether it was certain money in a property settlement agreement or certain money that was be held in trust someplace else. All of those had races. The race in this case was the ownership of the policy. And I hear you saying, well, he didn't have a chance to change the ownership. He did. He did that when he signed that transfer of ownership. If we need to go back and determine whether that's effective or not, we ought to send it back to the court.
Is unjust enrichment in itself, a finding of unjust enrichment, sufficient to support the constructive trust, or does it require something like a breach of an obligation or unclean hands?
I think it requires, the Dapper and Nelson cases had obligations. And so that obligation to do something. And in this case, she had no obligation to change the beneficiary, and she fulfilled the obligation by transferring the ownership. I would respectfully submit that this court has broad discretion to deal with this case de novo. And it occurs to me that if what we want to have happen in equity is to have what the court expected to have happen, the court could say, let's send it back to the trial court and this has been something I've thought about since these briefs have been done. But let's send it back and say he was expecting to get half, $25,000 of the cash value. Let's order that to be done. Let's order her to pay him $25,000 for the cash value and then ignore the fact that he didn't change, or accept the fact that he didn't change the beneficiary and award that pursuant to the terms of the existing contract. In other words, not make it an all or nothing situation. Give him what he is entitled to, what the court expected him to receive, what he expected to receive. He told the agent, I don't need to change the beneficiary. He was given those forms and he didn't return them back to the agent as a part of the transfer of ownership forms. So there's a lot of direct implications here that he did not want to change the ownership. If he did not want to change the ownership, then there's no unjust enrichment. The person he intended or implied to intend got the benefit of the policy.
Not if he intended to cash it out.
You can take out the cash value of $28,000 and still have the remaining beneficiary life insurance. So instead of receiving $200,000, he would have received $178,000, $68,000.
But wasn't the intent of the divorce in dividing the asset of the marriage to give the entire policy to him?
If the intent was to do that, the statute says you need to then designate that the beneficiary is going to change. The legislature said, no, we're not going to automatically disallow the surviving spouse the right to be named in the policy. And I suggest to you that there's a consolidation of identity here between Joni, Webster, and Blackjack. It's one and the same. And they treat it as one and the same in the course of all these discussions.
All right, counsel, I believe you've used your time.
Thank you very much.
Thank you. Thank you both very much for your briefs and your arguments. Very well done. And we'll get an opinion out to you just as soon as we can.